Welcome to CPE-HR Healthcare Reform presentation. Today's presentation that you've selected focused on how to determine if you are a large or small employer. This presentation assumes that you are familiar with other aspects of the healthcare reform law and are listening specifically to learn a little bit more about the rules and formulas for determining whether you're a large employer or small employer as defined by the law. One other comment I'll make about the healthcare reform law is that it's a very significant, large piece of legislation, and we continue to receive from regulators guidelines, clarifications, provisions that need to be followed relative to the law, as well as some changes that are being made to the original intent of the law. So we encourage employers to spend some time making sure that you're constantly updated on what's the latest requirement from the law, and CPE is positioned to help you do that. So let's begin. This subject that you've selected is related to determining whether you're a large employer or a small employer. And this is important because large employers, as defined by the law, are subject to a mandate, and that mandate is that they either provide coverage and provide coverage that meets certain affordable requirements, or they are subject to penalties. Small employers are not subject to these penalties and are not required to offer coverage. So how does the law define a large employer? An employer is considered to be a large employer if there's more than 50 full-time equivalent employees. An equivalent is the critical word here. We're going to look at a calculation that helps us understand what this equivalent formula is. A small employer is defined as being less than 51 full-time equivalent employees. The size of an employer is measured across control group rules. These are well established, although complex, IRS guidelines for determining whether an employer is part of a control group. And a control group usually involves multiple companies with common ownership across those companies. And there's some other complex provisions of the control group rules. If you're in a situation where there is common ownership or multiple entities within a parent organization, this would specifically apply to your organization, and you should look at the control group rules and how it applies to determine whether you're small or large. The formula applies is measured from the preceding calendar year. If less than a year, it's based on the number of employees reasonably expected to be employed in the current calendar year. And one other note about the measurement criteria is that if there's more than 50 employees for 120 days or less, the employer is not considered a large employer in that year. So let's look at what the formula looks like. First of all, we're measuring employees that are hired to work 30 or more hours per week. These employees are considered full-time employees. Seasonal employees hired to work less than 120 days are not counted in determining large or small. Part-time employees, these employees are included in the calculation, and the formula for these employees is that their hours are added up and divided by 120 hours to get to a full-time equivalent number. Then the full-time employee and the part-time equivalents are added together to get the total full-time equivalent employee count. If the result is more than 50, you're a large employer. So we have an example at the bottom of this page, and in this example, this employer has 30 full-time employees working 30 hours or more on average, and they have 20 part-time employees working less than 30 hours. In this example, we've added up the hours of the part-time employees, and if they're working 96 hours per month, that totals 1,920 hours. The 1,920 hours is divided by the monthly average of 120, and we get 16 equivalents. from the part-time employee count. 16 part-time employee equivalents plus the 35 full-time employees equals 51 full-time equivalent employees. In this example, this employer is a large employer. We've also, on the next page, included an illustration that helps you to see the calculation in a situation in which some of your part-time employees may be working more than 120 hours. And so in this illustration, we're showing 20 part-time employees, some working 96 hours, some working 80 hours, some working above that, 130, 123, 140. And so what we wanted to illustrate in this exhibit is that total hours worked is 2,011. However, when you cap the hours at 120, total hours worked is 1,968. And it's the 1,968 that you use in the formula to divide by 120 to get your 16.4 full-time equivalents, and then add that to your full-time count. So it's not a straightforward how many are working more than 30 hours to determine whether you're full-time or not. The formula requires that you include in your count your part-time employees and the hours that they're working to determine whether you're full-time or part-time. Important distinction with this calculation that it's specific only to determining whether you're small and large. Doesn't mean you have to provide benefits to part-time employees. You just have to determine whether you're a small employer or a large employer. And the implication of that is, if you're a large employer, the mandate applies. You have to provide coverage, and if you don't, there are penalties that would apply. If you provide coverage and it doesn't meet the mandate requirements, there could be penalties that apply. This page that you're looking at is the CPE benefit specialist staff. These individuals can help you understand not only this subject but also other aspects of the healthcare reform law. I encourage you to reach out to CPE. You have their emails and phone numbers of the individuals on their team, and they'd be happy to answer questions you might have about the healthcare reform and other provisions. Thank you so much for attending, and contact CPE if you have any questions.